Hey everybody, Jonathan here. Hope you are all doing well. It is February 12th, where I'm at in Atlanta, Georgia. It is 40 degrees and raining, pretty miserable. Although this weekend it was like 75 degrees and sunny. So I'm looking forward to spring. The cold, rainy weather is, I think I've had enough of it. So hopefully where you are, it is not terrible. Although I understand that there's a number of snowstorms heading across the country. A friend of mine in Washington, D.C. sent me some pictures of snowfall up there. So I'm sure a lot of places. And Jen, my paralegal in Nebraska, sent pictures of snow up there. So I'm sure winter is still in its all its glory right now. So anyway, hopefully you all are staying warm, and we'll be done with all this at some point in the near future. Okay, so let's kind of go right into the comments. By the way, I was supposed to have a guest this week who's an appeals lawyer. She couldn't make it, but she's going to come next week. So look for the notice. It's going to be a lawyer who does appeals work, both at the Appeals Council and federal court. Um, Adriana is her name, and she deals with all the kind of once the case is denied at hearing, she takes it to the next level. And, we're going to hear from her some of the things going on at the court level, at the district court and appeals court level, that kind of tell us what judges have to do at the hearing level. So I think that'll be very interesting. I'm going to have some questions for her. But if you have any questions about appeals council or district court matters, save them up. And next week, Adriana Del Toro is going to be here to answer some of those questions. All right, we've got Christina is back. Last week, Christina was a little bit late getting here, but she is on time. Christina, good to see you again. She's, I think, been with me every single live stream. Really appreciate that. Jim Elliott says, hello. Hello, Jim. Hope you're doing well. I actually talked to one of my regulars today. I'm not sure if she's going to be on or not, but we talked about her case, and we had a date less insured issue, but we'll, sometimes that happens. We had a nice chat. So it's always nice to talk to some of the folks that are regulars here, and maybe she'll come and we can talk more about what her issue was kind of anonymously, but that was just something that was kind of nice to do. Okay, so we have TEMJR, TE major maybe. Can you win your case if there's no diagnosis, even though all the reports over the last 4 years show blockage on my CT scan? Doctor's appointments every 2 to 3 months for 4 years. It shows all the symptoms. And the ER visit said there's nothing much they can do. So it sounds like what you've got is some sort of an idiopathic problem. Idiopathic means there's no specific cause. And you can win disability if there's not a firm diagnosis. Now, it does help to have some sort of a provisional diagnosis, meaning, they have some idea what it might be. Again, sometimes you have pain, you have discomfort, shortness of breath, and they don't know exactly why. Obviously, in that situation, you're going to need, evidence of ongoing doctor's visits, and you need the doctor to basically say that you are not making this up, you're not malingering, that this is a real syndrome, but there's just no organic known reason for the cause. Maybe they've tried medications to address it that have not worked. So yes, you can win. It is more difficult because, as I mentioned many times before, Social Security really likes objective evidence, which means something that's in the form of an MRI or a CT. And again, he says here the CT shows a blockage. I'm not exactly sure what part of the body, what the underlying symptoms are. But, if there's something there that says there's something abnormal on the CT, that would certainly help. But, otherwise, you're going to need to have doctors that basically say you're not making this up, this is legitimate, and they just can't figure out what it is. Again, it would help if the doctor said this is, it could be one of 3 or 4 things or a combination of those things. And even if there's a psychological component to it, that's okay too. But I think it would be helpful to have some guidance as opposed to, we have no idea. Realize things like fibromyalgia, that's a chronic pain condition that there is no, way to image it, but it can be debilitating. And Social Security recognizes that it does exist. And there's idiopathic neuropathy, for example, where you have numbness and tingling in your hands and feet. They don't know why. It may not even show up on an EMG, but there is, some evidence that it does exist. So yes, those things can support a favorable decision, but it is certainly much more difficult, is how I would answer that. Blue City Garage, I think, has been here a couple of times. Filed 9 months before being rear-ended in a motor vehicle accident, had a CE last week. Will a settlement affect any back pay that you receive? Thanks for your time. If I get denied, I'll be calling you. If it's an SSDI case, which is where you've paid into the system and they're basing your payment, your disability claim on earnings that you've paid in, you've worked relatively recently, and you've got enough credits to qualify for SSDI, then a car accident settlement will not impact it at all. There's no asset test, there's no income or asset issue in SSDI. In SSI, it would be a problem, because that is an asset that would most likely take you over the $2,000 asset limit for SSI. So I would tell you that if it's SSDI, not to worry about it. SSI, it's probably going to disqualify you from SSI. Kevin Johnson says, I applied when I was 57. He's 59 now. Bad left knee, which needs surgery to replace it. Recon started in April of 24. The adjudicators know the grid rules. They want you to just go away. And he does live in Tennessee, he said. I think it may be a little harsh to say they want you to go away. By the way, speaking of recon, it's kind of interesting. We've had a couple of recon cases in my office the last few weeks that have been processed at recon. The denial issued like 2 weeks after we filed it. So, recon I've always felt has been kind of a waste of time. And I think that, in some offices, they're so busy. I'm thinking what's happening is that they just basically say, we're just going to deny every recon case and just move it to a hearing so we can focus on trying to catch those cases that should be approved at initial. That may be something what's going on. I don't know. But so I think, but to answer your question, the adjudicators, many of them do know the grid rules. Not all of them, many of them do. Realize that the grid rules, and I had this conversation with somebody just the other day, that the grid rules say, let's say at 57, you would be, the light grid rules would apply. So even if you could do light work, you were disabled, assuming no transferable skills. The question is, if your past work was highly skilled or even moderately skilled, then part of the grid rule is to make a determination that those skills would not be transferable because you don't have the capacity to focus and maintain attention and concentration or pace of work. Many times this relates to what they call non-exertional impairments, pain medication side effects, pain, depression, things that are not physical, because realize the grids are only on physical limitations, but these non-exertional issues, again, pain, medication side effects, and so forth, would reduce your capacity to focus and concentrate. So adjudicators are not going to be very comfortable making decisions about your capacity to focus and concentrate. And that's where it's going to go to a judge. Now, if it's been since April of 2024, now we're coming up on 10 months already. I think what I would do is I would reach out to your U.S. Senator in Tennessee, one of the two of them, and ask for a congressional inquiry. That is too long. I think anything more than 5 or 6 months, reach out to your senator. And I will tell you, I've had 3 or 4 people this week alone email me to say that they did that, and lo and behold, their case either got approved or it got denied, but it moved on. So I think, Kevin, it's been 10 months, that's way too long. Reach out to your senator and say, I've been waiting 10 months. It's a real hardship. I'm 59 years old now, applied for disability. They just need to make a decision. If they're going to turn me down, fine. I meet the grid rule. Would you please ask them to look at this case with the grid rule in mind, number one. Number two, just do something. Just give me a decision one way or the other. And I think that, that'll move your case to the top of the line. So I think that would be helpful. Hawks Fanboy 11. Should I argue my fibromyalgia was caused by my PTSD from a childhood sexual assault, given that your age and gender are both something the judge is likely to use against me if I file for disability just for the fibro? I think that, you would argue in that case both fibro and PTSD as being disabling conditions. I don't know that PTSD is recognized as a definitive cause of fibromyalgia. My personal feeling is that fibromyalgia is a form of shock, both emotional and physical shock to the body, and the body kind of shuts down, has a pain response, and makes it difficult to function. That's my theory. There are other theories of what fibromyalgia may be. But, I will say that generally speaking, the profile is female or females, in their late 40s, early 50s that have real type A personalities and really high stress jobs. That's kind of what they typically, judges are going to normally see that. A male fibromyalgia patient is very unusual. 29 is very young. I hate to tell you this, you're going to have a really, really, really uphill battle to try to win. But I think that the PTSD actually, if you've got evidence of that, or if you've got therapy notes that talk about childhood abuse, I've actually won cases for clients who are younger based on PTSD from a really intense childhood trauma. And you could, I think, argue that the fibro, the pain, is sort of a result of the body, the expression of that trauma, and maybe focus more on that than the fibro. Because again, winning on fibro at 29, male, I mean, if you can do it, more power to you. I just don't know that that's realistic. But the PTSD, tends to be less age specific. If you had a terrible trauma, and again, it's documented, there's evidence, you've seen therapists, they all recognize what you've gone through. You can set out what it means, what the triggers are that cause you, to kind of shut down or to have bad reactions. That may be a better argument. All that being said, 29, difficult, male fibro, extremely difficult. It will be an uphill battle, but, again, if you can't work, you can't work. Certainly give it a shot. Lily says, I contacted my Georgia DAS, GVRA, non-medical adjudicators. She said she never heard of EM 25009, looked it up and said that it does not apply. Now that is ridiculous. Of course it applies to Georgia residents. And anybody who tells you that is either lying to you or just totally misinformed. Social Security is a federal program. And this emergency message, and basically what it says is that at the adjudication level, this is an emergency message issued by Social Security 25009. At the adjudication level, if there is a shortage of medical experts, and they don't give a specific definition of what a shortage would be, but I suspect it may be a numbers calculation at a certain number of pending cases, a certain number of hours available for medical experts, and if that number is the ratio is too low, there's not enough medical experts to cover the amount of outstanding cases, then in that situation, if there's a physical impairment, adjudicators with a certain experience and training can make a decision to award a fully favorable decision without having the case go through medical review by a medical specialist. That's what this emergency message says. And as I talked about last week, what it will do is it will empower Social Security to clear out and approve, back pain cases, serious back pain cases that, are not listing level necessarily, but are significant enough where an experienced adjudicator can look at it and say, this person's got 2 herniated discs, they've gone through surgeries, not been successful, they're on pain medications, and they're on Neurontin, they're on Percocet, they're on all kind of Norco patches, things like that, and it's not really working. It will allow them to clear out some of those cases. Again, it's got to be physical, it's got to be fully favorable, and it's got to be a situation where there's not enough medical experts to man the office, the adjudication office. But it absolutely applies in Georgia. It applies in every state. And that person told you that. That's just an example of poor training, poor continuing education by Social Security, if in fact that person told you that. And if you have that person's name, and again, I don't ever like to say somebody should be fired for that, but that's just wrong. And, that's the supervisor of that office needs to understand that they've got a really misinformed employee there, because that is completely and unequivocally false. Okay. She says she remains in the queue for a medical consultant. You wrote to a Georgia senator. And if you hear back, say, tell the senator's office, whether it's Ossoff or Warnock, that you were told that this emergency message does not apply in Georgia, and let them know, let their Social Security liaison know that they have people in these adjudication offices that are misinformed, but you did the right thing. And again, it does apply. So that, if anybody else has heard that, please let me know, but that is absolutely not correct. All right, Kevin says, how much impact will DOGE, that's the government efficiency, have on SSA if they start massive CDRs with a new emergency message? The new emergency message is not about CDRs, but, look, there is a narrative out there that there is a ton of fraud in Social Security. That's been for years in Congress. And, you hear things coming out of the DOGE office that they're going to really cut back on fraud. There's a difference between a person collecting Social Security, on behalf of a dead relative, that is fraud, versus a person being approved, by a judge or at the adjudication level for a medical condition that is subjective. And I think people typically, some people in Congress conflate that. They think that, there's too many people that are approved because of depression or fibromyalgia or chronic pain, as opposed to outright fraud. There's two totally different things. Fraud would be, getting a fake doctor to write a report, or, taking something out of a record so that a judge does not see there's evidence of alcohol or street drug abuse, or that there's a doctor that said that there was nothing wrong. You sanitize a record, or again, you're collecting on behalf of someone who's passed away, or, there's some other fraudulent activity. Two totally different things. So it's not the same as questioning the standards of approval. Will we see a tightening of the rules to obtain Social Security? There's been talk about, changing, access to attorneys, reducing attorneys' fees, eliminating the grid rules. A lot of talk about a lot of things. Nothing has happened yet. Is it possible? It is possible. And obviously, if they, reduce attorneys' fees, what that's going to mean is that, attorneys in this area are going to be either not do it anymore, or they're going to just be so selective that people that have viable claims but are not slam dunk, I hate to use that word, are not going to be able to get representation. I suspect that the judges aren't going to be very happy to have a lot of pro se, which means non-represented claimants appearing before them, nor would Social Security be very happy to try to get, things done without the assistance of attorneys. But, we'll just have to wait and see. And hopefully that will not be the case. I mean, I think that, statistically, the amount of fraud in Social Security is extremely low. But, we don't know what's going to happen. But I will tell you, on this live stream, if I start hearing things that there is an outright attack on Social Security, and generally speaking, if there would be probably a deadline. It would be as of a certain date, these rules change. So we have not heard anything like that at all. Calvin H. says, good evening. Good evening, Calvin. Can a diagnosis of overactive bladder help a disability case? Over the 2-3 years of waiting for decision, how many times should you get an MRI? As far as the MRI, I think that's going to really be more of a medical question from your doctor. I think that, when I go to a hearing, if I have an MRI, every 18 months or so, that's more than enough, even every 2 years. Beyond that, you start to wonder whether things have maybe changed. So I would say 18 to 24 months, assuming there's a medical necessity. Realize when you undergo an MRI, you are exposing yourself to, radiation, not a ton of it, but you shouldn't have MRIs every 3 weeks. So, there's that as well. But I think it's really more of a function of what your doctor says. As far as overactive bladder, absolutely. I win a ton of cases on situations where clients have bowel or bladder problems. If there's evidence that you've got to go to the restroom every 30 to 45 minutes, it's going to be really hard to be reliable at work. And judges recognize, I've never had a judge not recognize that a person with documented, bladder issues, urgency and frequency, that they're getting treated for, or that the doctors are referencing it, or they're taking medications like Lasix, or they have conditions like diabetes, which often cause frequent urination, or overactive bladder, interstitial cystitis. These conditions are ones that cause that. And yes, that can be a real problem, because remember, the issue in a disability case is whether you have the capacity to be a reliable employee 8 hours a day, 5 days a week. And if you're going to the bathroom every 30 to 45 minutes for 5 to 7 minutes, now we're talking about a 10-minute break every hour. And in the Social Security world, that takes you off task. And if you're off task for more than 10 to 15%, it varies depending on the vocational witness, but minimum, certainly at no more than 15% of the workday, which is going to be like an hour or so, hour and 20 minutes of a workday, then, it's going to be impossible for you to sustain competitive employment. So yes, overactive bladder would be a very, very powerful symptom that I think would certainly make it a lot easier to win. Jim Badal, hope, Jim, I'm pronouncing that correctly. I've had 5 surgeries, spinal surgeries. That is a lot. I had discitis at the L5-S1, autofused by vertebrae, no mobility, range of motion, lumbar, neck, disc protrusions. Do I have a claim? You're 60? Absolutely. I think that, you've got a claim under both the grid rule, because I can't see that you could even, first of all, I don't think you could do any work at all with that level. You've had 5 surgeries, they've not been successful, you have limited range of motion, you don't mention pain, but I suspect that there is a level of pain with that. But certainly no one's going to expect you're going to be able to lift 20 pounds, which is what you have to do at light work or stand and walk 6 out of 8 hours. So I would argue, again, subject to reviewing a medical file, that you would likely not be reliable enough because of pain, limitation of motion, likelihood of missed time from work, being off task, that you would not be able to do any kind of job. And the alternative, that you're limited to sedentary work at best, and you meet the grids there, or an alternative that even if you could do light work, you're still disabled. So, all you really need to prove, assuming there's a level of pain or medication side effects that interfere with focus, attention, and concentration, that I don't see that you could do light work, standing 6 hours, lifting 20 pounds occasionally. So I think that, based on what you've said, I think that's a winning argument. Yes, absolutely. Trish Wade. Trish is here a lot. How are you doing, Trish? I hope you're doing well, and thank you for stopping by. No Sky Daddy is a regular visitor. I know him quite well, and he is here. Carrick, he is 56, and we are waiting for a hearing date. Obviously, one of my clients, the Carrick part does not ring a bell, but obviously one of my clients, multiple issues such as type 1 diabetes, which is brittle, multiple weekly hypoglycemic episodes with hypoglycemic, let's see, and they know what the medical terminology mean to understand how it impacts daily living. So, all right, to answer your question is, if you're brittle diabetic, my experience has been type 1, that many times a big problem is low blood sugar, not just high blood sugar, but low blood sugar, which A, is very, very dangerous, but B, you pass out. So certainly that's going to eliminate jobs around hazardous equipment, moving mechanical parts, driving motor vehicles, things like that. Weekly episodes, hypoglycemic episodes, hypo and hyper, I guess, glycemic episodes, which I guess is low blood sugar, yeah, that's going to be a real problem. Yes, they'll know what the medical terminology is. Judges are very aware of that sort of thing, as are adjudicators. When I do a brief, I will certainly define it. And I do this actually in my briefs. I don't assume that judges always know what the terminology is. So if it's a kind of an unusual term, not that hypoglycemic is an unusual term, but if it's an unusual term, I'll define it. I'll reference National Institute of Health website, WebMD. So, I always explain what it is. But yeah, I think that you can assume that the medical experts at the adjudication office will know those terms, as will a judge. And if a judge doesn't know, a good judge will call a medical expert. But again, I define them in my brief. Cancer-free, it's you again. Hello. And we're talking with my helpmate with the process. How would I go about asking for medical records as SSA has been issued? Where do I get the records? If you are represented, your attorney can download it. We have access to files now at Initial and Recon. So I frequently have my clients say, can you get me a copy of the record? I'll just download it into a PDF file. It's a zipped PDF file. If you know what that is, and I'll send it to my client. They can unzip it, or if it's just a PDF file, just send it like that, and that you can see what they've got. You can also get a table of contents from the Electronic Record Express file. Your attorney can do that. I have had some people tell me that at the hearing level, they can contact the hearing office, even if they're represented, and get a CD. So, there's a lot of ways to get it. I believe that if you're not represented at your Initial and Recon, you can make an appointment, if you can get through, to your local Social Security office and take a look at the record. But, what you're looking for would be so easy to get a PDF of it. That's what I would do. And Cancer-free says, there's work activity a few weeks ago. The guy that did it with me was not aware of me oxygen at all. So what am I messing with when it comes to filling out this form? Random. Okay, so are you saying that the people at Social Security was not aware that you're on oxygen? So again, not everybody in the adjudication office is going to have access to your file or have looked at it recently. If you are, the work report is obviously not going to really be something where you're going to have to mention you're on oxygen. I think I remember you telling me that you're on oxygen. You have been on oxygen for quite a while. You've got a strong case, I believe. But again, I think you just fill out these forms, and, whenever you have a chance to tell them that you're on oxygen, repeat that, because that is going to make your case, I think, a real strong argument, because, I can't think of a job where you can do that while you're on oxygen, because again, it's going to be bulky, it's going to slow you down, and obviously it interferes with activities of daily living just because you become short of breath so much. All right, what does this mean, asks MT. This is for my SSD and SSI claim to assignment to adjudicator K. Ryan, medical evidence or record received in cases and referred to medical review. Good question. What that means is that the adjudicator is K. Ryan, and they don't tell you the first name. It's Kevin Ryan or Kendra Ryan. We don't know if it's male or female. The MER, medical evidence of record, which is the evidence that the adjudicator has gathered, will be sent to a medical specialist in the adjudication office. Remember, I talked about that emergency message where if they don't have enough of those medical consultants, the adjudicator can do it on his or her own. But if there are enough consultants, they have a doctor, and these are typically, they could be any type of doctor. It doesn't have to be a orthopedist. It could be a pediatrician. A lot of times they're retired or doing this to make a little bit of extra money, and they'll review the file and they'll make a recommendation as to whether they feel that it shows a disabling condition. Many times they're very focused on whether you meet a listing, but sometimes they will talk about your functional capacity or even, set it up where you could win under the grid rules. But, these doctors are not known for finding a lot of disabling condition. So don't be surprised if it doesn't turn out the way you want it to turn out, because again, these doctors are, they're getting paid not a whole lot of money by Social Security, and they're just reviewing these files. They have a certain amount of time to review them. They get paid a flat fee, which is not very much money, and that's what you got. So it's just the way the the way the system is set up. But that's what that means, is the case is being processed the way it should be processed. Okay, let's see here. Let me go back here. All right. Okay, MT says you need the U.S. senator, not your state senator, by the way. So when you say you get your senator, it's the one that goes to Washington, D.C., not the one that goes to your state capital. State senator has nothing to do with Social Security, whereas a U.S. senator does. Terry Clemens says, my SSDI case has been remanded by the Appeals Council. My hearing will be in March, but the Appeals Council remand to a different ALJ. On the first remand, the old ALJ is still here. Is that good? Probably so. I mean, usually if the judge denied you, especially if the judge is a low approval judge, you want a different set of eyes looking at it. So I think that's a good thing. Almost always, that's a good thing. Ruth, how are you doing, Ruth? You were here last week, and I really appreciate it. You were near Warner Robins, Georgia. I've been through Warner Robins many, many times. That's near Macon, kind of in the middle of the state. Should you include motor vehicle accident case where you want an award for loss of future work benefits? Where do you include document? I think the most important thing about that would be the medical records. I don't know that you need to really worry about the award or the future work benefits. That's not going to be binding on Social Security. They're going to look at the medical evidence. So if you've got medical records from your accident, MRIs, X-rays, treatment for back or knee or shoulder injuries, that's what they want. But I don't think other things regarding that accident are even relevant to Social Security at all. Martini shot. What happens in the final 15 to 30 days of medical review? Is this where they might want to see me? They're not at the adjudication level. They're not going to want to see you. And I think that my experience has been when you talk about the timing of it, and you see these things on your My Social Security statement that you're at stage 3, or they expect that it's going to take another 100 days. I think it's just all a bunch of BS. I don't think there's any way for them to know how much time it's going to take. 15 to 30. It's just they get done with it when they get done with it, and anything they tell you about how much time is just a estimate. It is not accurate. Do not rely on it. So I think it's just a matter of when they get finished with it, and the adjudicators and the medical experts are overworked and they're taking longer and longer. So hopefully it's 15 to 30 days, but don't be surprised if it is longer than that. All right, Teresa Bond. Will initial applications continue to take 300 plus days for medical review? I've also asked to consider the grid rules. Thanks for the information. I think it depends on where you live. Texas and Florida, and even Georgia now is getting bad. It can take, it's ridiculous it can take that long, but 300 days is not out of the question. I'm guessing it's going to get worse before it gets better. So, I think that, getting your senator involved is helpful. Asking them specifically to consider the grid rules is helpful, but you have to realize something. That case is in the adjudication office, state agency office for 300 days. Most of that time, it's just sitting there. Now, it's not a physical file like it used to be. And I actually went there, by the way, went to an adjudication office near where I used to work. This is going back 25 years. And I literally walked in this office, and there were physical files, piled to the ceiling, dozens of tables. They're just sitting there. So that file is not being worked on for 300 days. It's sitting there, and it's in a queue. And at some point, down the road, 9 or 10 months, it's going to come up on somebody's computer screen to look at it, and they're going to look at it. And they'll send out medical requests, and then they'll calendar it for 3 or 4 months for them to come back. If they come back, then they'll send it to the medical specialist. If they don't all come back, they'll send out an additional request and calendar for another 3 or 4 months. When that comes back, whatever they've got, they send it to the medical specialist. That person has it for a month or two. Then it comes back to the adjudicator, gets in another line, another queue, and at some point, based on the notes, the adjudicator issues a decision. That's what's going on. But literally, the amount of time actually spent on your case during that 300 days is about 4 days, but it's because it's so backlogged, it's just sitting there. So it's not, like I said, in a file on a desk. It is on a computer, but it's just being nobody's touching it. They don't have enough people to do it. So that's what's going on. But yeah, I do think it will continue to be a very, very long time. Okay, it's referring to IBD every 3 months at the weekend of the ER. Let me go back here, what you were asking. I'll make sure I'm talking to the right person. Okay, you were the gentleman or lady, I'm not sure. There's no diagnosis. So you've got, idiopathic irritable bowel disease. And, if there is evidence that you have urgency and frequency that cannot be controlled by medication, yeah, that can be a legitimate case. Again, difficult, because it's idiopathic. My buddy Jeff Herman from Arizona is rubbing it in my face. It's 65 and sunny there. Any interesting hearings? Yeah, I mean, I'm doing 2, 3, 4 a week. There's always interesting things coming up. Just a lot of different medical conditions. I actually have one coming up next week where my client passed away. He died, and while waiting, and so we're arguing for essentially a closed period of time. This gentleman had just a lot of medical issues that just he could not work. He had COVID. I actually had 2 or 3 lately. He's one of them, where it's long COVID. Where basically the person was having some heart issues, some breathing issues, and then COVID comes along, and everything, the heart and the lungs, got a lot worse. So I got 3 or 4 of them right now, kind of long COVID complications, let's call it that. So those are kind of interesting. We'll see how that turns out. I've got a couple where there have been some substance abuse issues. One with a person who's a recovering alcoholic. The evidence is that this person has stopped. I've got another pretty strong case where the person was on meth and cleaned up, but unfortunately being on meth tends to not help your body, and has non-alcoholic cirrhosis of the liver, as well as something called pulmonary hypertension, which is a very serious condition, requires oxygen, causes a lot of complications. So it's going to be really interesting to see, number one, whether the judges are going to consider the long COVID element of these cases, and number two, whether I can prove in some other cases that the substance abuse caused enough permanent damage that even though the person's now sober, A, will they approve it because there was substance abuse, and B, will they change the onset date to the time after the substance abuse ended? So that's really the 2 interesting things going on now. So I'm wonder if you ever had any of that. So, but that's what's going on here. That's what the interesting thing is going on here. Okay, forgot to ask. Ruth says, in Georgia, what grid rule apply to 54 and 8-month-old applicant? Well, first of all, the grid rules are national, Ruth, so it's not just in Georgia. It can be any place. I think that until age 55, the sedentary grids apply. There is some, and I will say this. At one point, there was a notion that judges could use something called the grid framework and apply the 55 grids to people who were 54 and 8 months or now. I read someplace that that's no longer allowed. I got to find out about that. But so I'll say for certain the sedentary grids apply. Whether you could argue the light grids at the close to being 55, I'll have to find out. Again, I read somebody commented that that was eliminated. And certainly I would say if you turn 55 during the pendency of your case, Ruth, then prior to 55, this set of grid rules applies. After 55, the light grid rules apply. So but I don't want to give you wrong information. I will find out. Maybe Jeff Herman knows. He's here. Whether there's a way to use the grid rules 2 or 3 months before you hit that age category. Again, I've read that it is that you're not able to do so, but I could be wrong about that. And TE comes back with there's blockage in the canal I'm assuming sort of GI blockage with the idiopathic irritable bowel disease. So again, now that's starting to look like you've got objective evidence. They may not know the cause of the blockage, but there is a blockage. So that's making your case that much stronger, I would say. What is the remedy for finding that the email in the Social Security portal has been changed for a person? Can Social Security attorney help or another legal specialty for that? When you say are you talking about your email or somebody else's? I'm a little unclear. If your email has changed, you should be able to contact Social Security and tell them, just like you would with an address change. Now, they don't really email you very much, but I think that, I would change it if that's what you're asking. I would change it in writing. I've got this ongoing problem in my office where years and years ago, I did a little contract work for a non-attorney rep firm called Brown and Brown. Some of you all may have heard of them, and they would pay me a flat fee to do hearings. And back in the day, I didn't have as much work as I do now, and so I would do them. And they pay me a few $100s. I do a hearing, and that was actually a good way to get some experience. And I met some really nice folks doing that. Well, for some reason, they still associate me with Brown and Brown. And every year I have one or two cases where my fee doesn't show up. They send it to me, care of Brown and Brown, who sends it back. Then it ends up in limbo, and I got to fight like crazy to get paid. So they're not real good about that. And I think that, you may have to send in multiple address changes or email address changes to get some relief there. But if that's what you're asking me. Ms. Crystal says, I received my fully favorable at hearing level, still in step 3 online, says the appeals counsel is reviewing the judge's decision. Somebody asked about that last week. The appeals counsel will, at random, review a fully favorable decision just to make sure the judge, properly analyzed the evidence. I've only had in 30-something years one of those where it actually got reversed. The rest of them, the appeals counsel just said they processed it through. So it sucks because you've gone through, you won, and now the appeals counsel is saying, wait a minute, we're not going to, even though you've won, we're going to put a hold on it. Nothing you can do, just got to wait for them to do their review. Steve says, I've got 16 work credits of the 20 I need for the last 5 years. Can I file as soon as I earn enough credits? Do I have to work all year? Thanks, I'm signed up already. Answer to your question is you don't need to work all year. You need those 4 credits. So if the amount of the credit, I think, if I'm not mistaken, you have to have like $8,200 of earnings for the year to get all 4 credits. You could earn that, $8,000-$9,000 in January. The first week in January, you get all 4 credits. So you can get your credits. You don't have to work all year. You just need to work long enough to earn enough money to get all 4 credits. And again, I've got it on my For Social Security Disability site, the amount of money, but again, it's something in the neighborhood of $8,000-$9,000 to get all 4 credits. As once you earn it, you don't need to keep working. Now, obviously, that will raise the question of why did you stop working? And, the answer, well, I got enough to get my credits. That's not exactly what Social Security is looking at. They're looking at, do you have a medical problem that prevents you from working? Now, you could certainly say, I really did not have the capacity, but I needed to get the credits, so I worked and I stopped, but I think it's better to continue to work as long as you can. Then you could, legitimately say, I stopped because I had to stop, not because I had some, non-medical reason for stopping. So got to be kind of careful about, how that's framed. And again, if you can work, you should work and forego disability because you'll be happier, make more money, and it won't be, you won't have to wait for 2 years. I would just say you have to look at this, from the terms of the way Social Security is looking at it, do you medically have reason to be considered disabled as opposed to you're trying to fit within the system. That is really not what the system is for. So you guys just have to be careful about that. Okay, so Carrick, we had already, I think, answered that before. Terry Clemens is 49 years old, have heart disease, diabetes, foot pain, back problems, high blood pressure, high cholesterol. My doctors think all my doctors RFC or functional capacity forms on your side, have a cane and a walker and a handicap permit. Yeah, I mean, I think that, you've got, based on all that, you've got medically a pretty solid case. At 49, the risk is that they go ahead and approve you as of your 50th birthday and say, well, as of 50, you clearly are disabled. At 49, we're not going to assume as much. That could happen. But, if you're using an assistive device, which, by the way, I think, takes you out of light work, certainly limits you to a reduced range of sedentary, probably reduces you to no work. But yeah, I think it's, assuming that's what the record says, I think you've got a good case. But beware that they're doing this a lot. They're changing the onset date. So don't be surprised if they move it to age 50 so they don't have to pay you as much in past due benefits. George Young says chemo caused neuropathy, which is not uncommon. In EMG or nerve conduction study test confirmed it. You've got in all extremities 1,800 milligrams of gabapentin a day, which is a ton, a lot. And physical therapy, 57 years old, but a dock worker. Do you have a case? Yes, you absolutely have a case, because chemo, that's a legitimate reason you'd have neuropathy. The gabapentin probably makes you a total zombie at that level. You're 57, so I think you clearly meet a grid rule. Winning case. I think, subject to, if I'd looked at the medical records and there's something else in there that completely shocked me, but based on that alone, I think that, yeah, I would take that case in a heartbeat. Barbara Prince, 57, I received SSI. You qualify for SSDI. You got SSI back in 2021. All right, SSDI is not the next step, Barbara. SSDI is based on the earnings you paid into the system. So if you didn't have enough earnings in 2021 to qualify for SSDI, you don't pick them up by being on SSI, unfortunately. So there's no way to get to SSDI unless you have earnings record. And of course, if you're working, that's inconsistent with being on SSI. So I don't think that you don't graduate from SSI to SSDI is the point, unfortunately. So I don't think that there's any way, unless there's earnings, that you'd be able to qualify for that. Or you could presumably become eligible for SSDI as a disabled widow. If you have a spouse who passed away and you're between 50 and 60 and you became disabled within 7 years of that spouse's death, then you could go to widow's benefits, which is a form of SSDI. So that's the only way you can really do it. All right, Corlil Katana. Wanted a full-blown panic attack because of a claim over an upcoming exam for x-rays. Yeah, again, I think people misunderstand how stressful it can be to go to doctor's appointments, and especially if it's one of their doctors and they're going to do some sort of even an x-ray, MRI, things like that. People get panic attacks and MRIs because they're in this tube, and people get claustrophobic. But yeah, that could be a function of underlying PTSD or depression or anxiety. And so that actually becomes evidence if you had a panic attack. You're going to need more than that, obviously, to win, but that certainly could be a factor. Okay, and so Carrick, who's one of my clients, and then he asked, do they understand medical terminology? Yeah, I think they do. All right, Megan Moon is currently 70% PTSD and 40% with the VA. Just got total unemployability. Will the Social Security SSDI consider this? They will consider that. It is not binding on them, Megan. So even though you're found disabled by the VA, they don't use the same standard. You see the 70%, and they kind of break it down by body part. It is relevant because another federal agency found you disabled. The VA records will be considered, but it is not binding. So you could be 100% VA disabled, 100% back, 100% neck, 100% shoulder, 100% PTSD. It is not binding on Social Security. So that does not guarantee you're going to win. If you're 100%, you'll be moved to the front of the line. That's the big benefit, but it's not binding on them at all. And again, that doesn't make any sense to me. You got two federal agencies. Why do they have different standards for disability? You actually have multiple federal agencies. What is it called? The FERS, the employee retirement system, has a disability component, different definition. Makes no sense to me, but what it is. Jen from Nebraska, my paralegal, who's in a snowy Lincoln, Nebraska, sent me a picture of her front yard today covered with snow. She is online, so obviously did not got the power. Hello, Jen. And Corlil uploaded a document to Jen. And Ruth says, hello, Jen. And John says, hello, Jen. Megan says, Megan's 40%. Again, VA, it's not going to be binding on that. Christina, please do not forget to like the video. Yes, thank you very much. And Teresa's saying 40% fibro with the VA. Yeah, I didn't know that they rated on fibro, but I could be wrong. Sanithya says, I get $686 a month. Is that it? Can I qualify more if I'm a dependent? If it's SSDI, it's a function of what you paid in. So no. Now, if you have a dependent, your auxiliary can get a payment that's equal to a percentage of your benefit if they know you've got a dependent. So in SSDI, so if they don't know about that, yes, let them know you have a dependent. SSI, that's by statute, and they've reduced it, obviously. That would be all you'd be able to get. But SSDI, there could be some more money there if you have a dependent who is legally a dependent of yours, and they know about that. Maria says, these videos have helped me. Well, very good, Maria. Thank you for letting me know that. I'm glad that they do. By the way, let me know if you all see, I've been started doing this where I took a live stream and I cut it up into pieces, sometimes 3, 4, 5 minutes where I would answer a question like I'm doing now. That becomes its own video. And I'm putting them up there, into the YouTube channel. So I'll be curious if you think it's effective. Do you like that? I'm also doing more of the YouTube shorts where I answer questions in a minute. I'm putting it on Instagram, Ginsberg Law Offices on Instagram. So if you're on Instagram, please follow me there. On Facebook and Instagram are the same company, Ginsberg Law Offices. We have a Facebook page. So, find us and like us on Facebook. Jonathan C. Ginsberg is my Facebook. Not that it's my personal. I have two Facebook pages. One of them is kind of with my friends, and then the other one is all my business friends, as we'll call it, Jonathan C. Ginsberg. So friend me there, and I'll friend you back. We're all over the place. So I want to be on, like I said, Instagram. I'm trying to build that up a little bit. I'm doing Instagram page for my wife. We're doing these short videos using the vertical, which is a little different. And then again, I've got the shorts on YouTube, and I've got the videos on Facebook. So again, find us everywhere. Facebook, Ginsberg Law Offices, Instagram, Ginsberg Law Offices, YouTube, obviously, and then Facebook. Just find me, Jonathan C. Ginsberg, and friend me. Happy to friend you back. Okay, Luca Brasi from The Godfather, who's a Steelers fan, no less. What are your thoughts on Medicare, Medicaid getting the axe, much higher copays? You and I both know it's going to happen. I don't know. I think that I think Medicaid is probably more at risk than Medicare. I would be surprised if, they've always said that Social Security, retirement, and Medicare are the third rail of politics. I would be really surprised if they did much to it. I don't think there's going to be enough support in Congress, because even though the president is not going to run for re-election, he can't. Your senators and representatives certainly are going to run for re-election, and they're not going to have very many happy constituents if they vote to mess around with Medicare and Social Security retirement. Medicaid, SSI, there's not as much of a constituency, so who knows? Tara Upshaw says, hello, Jonathan and Jen. Hello, Tara. Chan Tet, who is here most weeks. Hello. Rodney. Rodney Blakeney has been one of our clients for years and years. We won his case a number of years ago, and he's kept in touch, which we appreciate. He's here quite often, so good to see you, Rodney. Christina says, please leave a 5-star review, and I will show you how to do that right there on this crawl. So yes, please leave me a review. I've gotten some actually really nice reviews. Actually, if you leave a review, say something. I've had a number of them where people leave 5 stars, they don't say anything. Just say, really enjoy the live streams. The videos have been helpful, whatever. But it's more helpful if you say something as opposed to just putting 5 stars. Again, I appreciate the 5 stars, but it would be nice just a couple of sentences. I've also got, you can leave it on Avo, which is another place. You can put it on Yelp, you can put it on, any number of things, but Google's obviously the big one. So if you found this helpful and you want to leave me a review, that would be much appreciated. And there's the link of where to do it there. And Tara says, everyone please subscribe and share. Thank you. And Jenny, who last week was the person, Christina was a little bit late. Jenny, took over and told people to like and subscribe, which I appreciate. Unfortunately, I had a death in the family. She told me, she's one of my clients, so she may not be here tonight, but Jenny, we're thinking about you and your family, and I hope, peace, because I know, what you went through is not good. Trump and Elon Musk take over the office impact. Again, they have not, well, I've never heard anything about Social Security disability being affected yet, but things happen real fast these days, so who knows? Teresa has already subscribed. Very good. Thank you. Tara Denise, 22 years old, never worked. IEP throughout high school. That's an individualized education plan, which means wasn't regular classrooms. Bipolar, anxiety, depression, panic depression, mood disorder, personality disorder, on several different meds. Should I apply? You would be applying for probably SSI. Now, if you have a parent who's on disability, you could apply for disabled adult child, which is a more robust program because it's part of the SSDI program. But assuming you don't have a parent, or I think even grandparent on I think it's got to be parent or guardian on Social Security, disability, or retirement, you're going to be an SSI only. Mental health cases tend to be less age dependent, meaning that a younger person with significant mental health issues can win. Still more difficult when you're younger, but you've obviously got a lot of stuff going on. Realize SSI is a means-tested program, Tara, and that means that any assets that you might have, that somebody might give you, any support you get from friends and family could reduce your SSI. But certainly medically, based on what you're talking about here, long history of it, significant diagnoses, I'm sure you're on medications. Have you had complications like inpatient hospitalizations, suicide attempts, multiple medication trials? That might be enough to push you over the edge. And again, even being younger, it does not mean if you had back problems, it's more of a problem being younger than if you have significant mental health problems. But again, you're probably SSI unless you could go as a disabled adult child having a parent and guardian on Social Security. Cancer Free says, what does OHO? It means Office of Hearings Operations. Funny story is that this office, which is where the hearings are held, has gone through, it used to be called OHA, Office of Hearings and Appeals, and it was ODAR, Office of Disability and Review. Now it's OHO, Office of Hearings and Operations. Like, why do you need to keep changing the name? It makes no sense to me. It's, I guess they changed. Now we have the Gulf of America, not the Gulf of Mexico. So I guess names can change, but they've changed it since I've been doing this work 3 times. It seems to me that, just keeping it at OHA, Office of Hearings and Appeals, would have been fine. It's just confusing people to change the name 3 times. But, there's probably some bureaucrat sitting in a cramped office in the bowels of an office building in Washington whose sole job it is to come up with acronyms. And so that's what this person did. I have no other explanation for it. But that's what it means. Office of Hearings Operations. Cassie Marie. She's 45, drove a bus for 18 years, has a hearing coming up. Medical records are good for the last 4 years. What do you think your chances are? Cassie, I would tell you that you don't win based on a diagnosis. So the fact that you've got radiculopathy, degenerative disc disease, is a diagnosis. What does it mean? in terms of your functioning. Now at 45, you have to prove that you cannot do any kind of work at all. So let's assume, as a starting point, you can't drive a bus anymore. If I said to you, here is a job, you're sitting in a air-conditioned warehouse, you're taking ink pens and you're putting them in a box. That's all you're doing, packing light items. Or you're monitoring security cameras, or you're monitoring, underwear coming down an assembly line. Something really, and you could do it sitting or standing, unskilled, sedentary type of job. Could you do that? And you have evidence to say you couldn't. So, radiculopathy obviously means you've got pain running into your legs and or arms. That may affect your grip strength. It may affect your ability to stand. You may need to move around. And what I would focus on would be the need to move around, not just sitting and standing, but you've got to move around, 8 to 10 minutes every time you stand up. And you want to be very specific about, I can sit for 10 or 15 minutes. I got to get up and move around for 10 minutes. I can stand for 10 or 15 minutes. I can repeat that cycle 3 or 4 times, and I got to lie down for 45 minutes. This happens twice a day. You want to be very specific. So the 45 is the problem in my view, unless the symptoms are extremely debilitating. Are you in pain medications? What do the MRIs say? Is it, degenerative disc disease, which everybody has, or is there disc involvement, a badly herniated disc, a bulging disc pressing on a nerve? These are all the things that you got to know. So it's really the effect of your condition, not the diagnosis. Sandy. When should I expect a hearing? I was given SSDI for a grid rule. What happens at the hearing? Well, I assume you've not been awarded SSDI, you're going to argue the grid rule. Usually the judges are not going to talk about the grid rules at the hearing. That's something that, what actually happens is, let's say, because I do a pre-hearing brief. And so my brief, I'm going to say, like I have one coming up tomorrow. I got a couple next week, both people over 50 and 55. So at the end of the brief, I'll say, our contention is that the combined effect of the claimant's, chronic low back pain, as evidenced by an MRI that shows a herniated disc, unsuccessful surgery, spinal cord stimulator that had to be removed, diagnosed bipolar disorder, diabetes, and medication side effects. We contend that there are no jobs this person could do. In the alternative, if there is some residual functional capacity, we contend that it would be limited to a reduced range of sedentary work. In the alternative, if this person is found to have more than sedentary work capacity, we contend it would be light or a reduced range of light work, such that Grid Rule 202.06 would apply. The judge will go through the hearing as if there was no mention of the grid rule. And then at the end, in his hypothetical, he'll ask a question, he or she'll ask a question, and usually will say, well, of course, if this person is limited to light and has no transferable skills, I understand that grid rule, the grid rule 202.06 will apply. However, let's assume a certain level of transferable skills. So it doesn't come up at the hearing except kind of in passing. The judge knows it because, again, I've said it in my brief, and they're not going to ask a question that specifically, considers or would find you disabled by the grid rule. In other words, a judge would not say, we have a 57-year-old claimant who is limited to light work with no transferable skills. By definition, the grid rule applies in that case. So a judge would not ask that question because presumably he would realize that the grid applies. Every once in a while they don't make the connection, but usually they pick that out. But it's not like you go to and you could certainly say in your opening or closing, please look at the grid rule, but it's usually something the judge would incorporate as part of the decision. I bring it up in my brief so that it is made very clear that's the argument I'm making. But that's how that comes up at a hearing. But yeah, you want to mention it if you're going by yourself or if you have an attorney, you want to mention the grid rule because I think it's very relevant. Again, I do it in writing. I typically like to do my briefs as opposed to giving an opening statement. I used to do both, but now that hearings are about 45 minutes, I don't want to spend 7 or 8 minutes of my client's time doing an opening when I've done a brief. So I'll just say, Your Honor, my brief is Exhibit 17E, rather than give an opening statement unless you'd like me to. My argument is set forth in that brief, and that way I don't waste my client's time. So that's what I do now. Lost Brooklyn. Having a small business selling tiny knickknacks, making less than $500 a month. Will that flag a CDR? I do have to let them know I'm doing just reporting. Do I have to let them know what I'm doing, just reporting in taxes, but an SSDI for 2 years? I think if you're earning anything and they send you the short form, you've got to answer that. Anytime you answer anything over 0 on the short form, I think it's 454, I think it's a short form, I'm sure. It's SSA 454, 455. One of them is a short form, it's like 5 questions. But if you answer that you're doing anything at all, they're going to want an explanation. So yeah, if you're earning $500 a month, that is less than SGA. That's not even using up your trial work period months. It does raise the question of, do you have capacity to do anything more? But, assuming that's all you're earning, you're making a little bit of extra money, it most likely is not going to have an effect. I think Social Security's got to really strike a balance, because on one hand, they want to encourage people to try to work. So if they started coming down on people and reviewing them because they're earning $500 a month selling knickknacks on eBay or at garage sales or at flea markets, then no one's going to even try to work anymore. So I don't think they want to do that. But I think that, the fact that you're earning something might, let's put it this way. If you answer 0 or no improvement, answer no to all the questions in the short form, a human being doesn't see it. If you answer yes, that there's been some improvement, or yes, that you're doing some work, even at some small level, a human being will look at it. Probably not do anything about it, but a human being will look at it. That's the only thing I would tell you. But I think you do have to report it. And look, I don't blame you. If I was on disability and I was getting $2,000 a month and I could make another $500 or $600 selling, crafts or something on flea markets or eBay, I'd do it. I mean, it's not very much money. Christina says, please share the live. Yes, thank you very much. Lost Brooklyn says, stop with the fear, nothing's getting axed. I tend to believe that. I don't think that they're going to just wholesale get rid of Social Security or Medicare or Medicaid. But I think we all have to be prepared that there could be some changes, because I think there will be. I just don't know what they're going to be. Muley, who's been here most weeks, just approved. Yes, great. But for some reason, they put your onset date to February of 25. Having on the paperwork, you ask them to look at it without appealing. No. If they've approved you but changed the onset date to last week, that means you're getting no past due benefits. You won't get benefits for the first 5 months. You can appeal that. The risk is that if you appeal it and you lose, you get nothing. But again, is there really a risk? If they've approved you administratively, is it really a risk that they're going to turn around and give you nothing? Probably not, but it is a risk. So, that's a decision you've got to make. But I mean, I generally find that, if there's evidence going back now, if you turn 50 on February 7th, now the grid rules apply where they didn't apply before. If you turn 55, it's more of a question, because now you're there's an age category that can make a big difference there. But again, come back to, is there really a risk? Because you're going to still be 55 or 50. If you go to a hearing, most cases, the worst the judge is going to do is just say, we're going to affirm what the state agency did, unless you get a crappy judge, in which case, you find yourself with 0. So it's a risk, not a great one, but it is a risk. Alec Y, 60 years old, filed for SSD on September 23, med exams, received total unemployment from VA, should be getting decision, depression, insomnia, radiculopathy, IBS, kidney disease, frequent urination. I think you got a pretty good case there, what you're telling me here. I would let them know that you've been upgraded to 100% VA. That'll speed things along, but I think that you've got, sounds like a pretty good case. I mean, that, 60 with all those problems. God first says it's wise to do the retirement disability 60 years old. The risk is if you lose disability, you're stuck at the lower retirement figure. But other than that, if you need the money coming in, go for it. Now, it will make it more difficult. If you're getting retirement benefits, it will make it more difficult to get an attorney, because what happens, and I've had this happen to me a few times, I take a client who's 63 or 64 getting retirement benefits. And so if we get disability, the retirement, let's say, was early retirement was, let's just pick a number, $1,500 a month. Full retirement is $1,800 a month. Well, what we're fighting over is $300 a month times however long. Well, if it's 2 years, you're not looking at that much money. 25% of, of 2 years at $300. So what is that? $300 times 24 is $7,200. That's $1,800 of a fee, which I'm not sneezing at, but not a lot of money, compared to cases where, the back benefit is $2,000 a month times 24 months. It's going to be obviously significantly more. So, I will take those cases, but selectively, because it's the same amount of work as it would be to take a case where I'm going to get a $7,000-$8,000 fee, as opposed to when I'm getting $1,800 doing the same work. I had one, for example, last year and this year. I think we ended up last year getting it resolved. I did 2 hearings, and we had a bunch of cases hearings reset. Spent a lot of time on this case. Ended up with a $1,600 fee. Did a lot more work on that case than I've done on other cases where I've gotten a lot more. Why? Because my client was getting retirement benefits. So, it may be more difficult to get an attorney, but on the other hand, if you need the money, take it, because it's going to be an easier case because you're older. So, it's just a matter of, decisions. 100% disabled, I assume is are by the VA. 49, have a court on the 26th. The VA doctor will not fill out forms, which they should be filling out the forms, but again, they don't always, but they should be filling them out. And he has got thoracic lumbar nerve radiculopathy that's getting worse. Again, I think you've got some significant medical issues. I think that having the functional capacity forms is probably less important than it was a number of years ago. The objective evidence like MRIs and CTs will carry more weight. The bigger problem is for 49. I mean, and again, I think that what we're seeing is a lot of times what they're doing is they're approving people at 50. Now, you've got a hearing coming up, you said, on the 26th, so basically you're saying I was disabled from 47, 48, 49, to the present. You've got to prove you can't do any kind of work at all. So the question here is, lumbar pinched nerve radiculopathy, those are medical diagnoses. What does it mean in terms of your functioning? And again, VA disabled does not mean anything. For Social Security, is not binding on them. So does this mean, what are the specific problems you have in terms of sitting, standing, walking, kneeling, crouching, crawling, things like that? You got to put, 10 minutes, 5 minutes, 30 feet, 15, 15 steps, something like that. You want to be very, very specific. Need to lie down 3 times a day in a recliner to take the pressure off for 30 minutes at a time. That's what you have to do. And again, it's always an uphill battle, when you're not 50, but you're close to 50. So it makes it better than if you were 43. So it's still an uphill battle, but not as much as if you were 43, but it's not as easy as it would be if you're 50, or particularly if you're 55. But again, you've got significant problems that I think, you certainly have a shot at it. Okay, they made a mistake. Several disabilities meet the Blue Book for years. Why February 7th? Does not make any sense. Be 55 in March. Then you know what? You have to look strongly at appealing the onset date. You just have to do it. And I think that a lot of people don't because they're afraid. And like I said, if you've got a solid case, they'll pay you. What I would do is I'd wait till the money starts coming in, then appeal it as long as you're within the 60 days. That way the money will be coming in. And hopefully, they'll be able to push it back. I've appealed a number of these changed onset dates. And so far, I don't want to jinx myself, I've won them all. the medical evidence has been strong enough. So if the medical evidence is there, I think you got to think about it. But, the risk, look, my clients on that situation, they're the ones taking the risk. And I tell them, look, I want to get paid on this case. I'd like to get paid more or whatever, but that's not the factor. The factor here is, what are you comfortable with? And I had one recently where the difference was $30,000. And I said, look, that's a lot of money. And, you got to really think about that. I think he decided he was going to go ahead and we're going to appeal it. I've had a couple more where they changed it by 4 or 5 months. I'm like, I wouldn't do that. It's not worth it. But if they're talking $30,000, $40,000, yeah, you got to think about it. But that's a judgment call. I am the good news. I'm on SSDI right now in a lower category with 1260 or SGAs, or way to contact someone about hitting my change the second category for blindness. Okay, this is a very interesting question. And basically what this person's asking is that there is a different payment schedule for people who are blind. It's higher than it would be for people who are not blind. I think you need to contact Social Security, maybe go through your U.S. Senator's office and say, look, I think I meet the requirements for blindness, and I want to try to get paid, try to get that paid more. So I think they would go back and make that determination, yes. Well, look, I said we have 200 viewers. That's a high. I think an all-time high. So thank you everybody for 203. So thank you everybody for joining me. I really appreciate it. And tell your friends, please. Chicky D. Kenny, I'm 57, applied in 21, been denied twice, found me a phone hearing with the judge next month. Is it normal for SSA to move my case to Tennessee? Assuming you don't live in Tennessee. It is not unusual now because the judges are, they have more judge capacity amongst the judges. So what they're doing is they're finding judges, since it's done by phone or video. You may be in New Jersey, the judge may be in Tennessee, the vocational witness may be in Arizona. Your attorney may be in Georgia, like I am. So it's not unusual at all. They just try to find a judge, who's got the time and a space on his or her calendar. So it is no longer unusual. It used to be, but it is not anymore. And good luck to you, by the way. Johnny number 5. I assume there's a Johnny number 1 and number 1, 2, 3, and 4. But Johnny number 5 says, hello, Jonathan. 56, been an SSDI for 5 years. I have a CDR going right now. Was scheduled for a physical, but Social Security called me and said, disregard. They received all your medical records, enough to render a decision. Is this a good or bad thing? Thanks for what I do. I think that is a good thing. You're very welcome. I think that is a good thing because I think it means that they've seen enough. They don't need to send you one of their doctors. They've seen enough, and I think that they will probably not terminate your benefits. It'll be based on that. All right, so Muley says, are we losing on 60 grand? You got to give it a lot of, if you're talking about 60 grand, you got to really think about appealing that onset date change. I think it's again, I don't want to say it's worth it because I haven't seen the medical, but that's a lot of money to be given up. And if they approve you, is it really likely they're going to find you not disabled? Probably not. I think it's probably worth strongly considering. Silver Monster, what is the average wait time from getting a CE until the report? About a week. The report's usually generated and uploaded. It'll be there in about a week, and your attorney can download it and send it to you. So it doesn't take very long at all. One of the things these doctors are pretty good at is getting those reports done quickly. Carrick says, do judges look at all information from the file or new info since the second denial? Judges look at everything. They do what they call a de novo review, which means they look at all of the evidence in the file, and they're not bound at all by the prior unfavorable decisions at initial and recon. So they're doing a completely fresh look. So again, I do a brief, I discuss the entire file. So yes, they're looking at everything. Martini Shot says, thank you. You are welcome, Martini Shot. Hope you found that helpful. James Ongst, 60 years old, awarded SSI 14 months ago. After 4 years of waiting, SSA program is so limiting and frustrating. I agree, because SSI, the earnings limits they have are such that they really almost discourage you from trying to work, which makes no sense. And it's just, they trap you in a cycle of poverty is what they're doing. So I think SSI is just it just needs to be updated. They haven't changed the income and resource limits in, I don't know, 20 something years. I mean, $2,000. I mean, it's nothing. They really need to change it. But again, there's no political momentum to do that. But yeah, SSI is not a great program, quite frankly. SSDI is not phenomenal, but at least you don't get offset if you earn a little money, you settle a car accident case. SSI, you get dinged for all that stuff. So yeah, it's not good. Esoteric Fitness, who's been here before, TBI survivor. Good to see you, Esoteric Fitness. Thank you for tuning in. And I know you've told me before about your TBI and how difficult it can be to function, and I've certainly heard that from other clients with TBIs. Teresa Bond, I'm here in Florida. My initial data review is July 19th. Should I contact my senator now? Yes, you should. We are now in February, and since July, that's way too long. All right, Caracas Kelly. Okay. Okay, and the answer, Kelly, is the judge will look at all data, not just what's new. The judge will do a de novo review. I think you just asked that question. But yeah, a de novo review of everything in the file. So when we do a brief, it'll cover the entire file. Specialist Ramirez. I'm an Iraq combat vet. Thank you very much, Specialist, for your service. I've heard from a lot of my clients who've been through been in the Middle East, Iraq, and Kuwait and so forth, just the burn pits, just the suffering that, not just the psychological with the IEDs and so forth, but the burn pits and all the other issues. I've had people tell me that their officers would give them like pills and say, take these pills, and wouldn't tell them what it was. Yeah, so it's just crazy. But you're a Iraq combat veteran with depression, severe PTSD, understandable, always on edge, anxiety, and psoriasis. They denied 3 times. Why? I don't know. I think that there are some, certainly at the adjudication level, depression, PTSD are the classic invisible illnesses, which means there's no way to image it. You can't take an MRI of the brain and see depression or PTSD. It's got to be something that is done by report. A lot of my clients from the military end up going to the VA, and the VA tends to generate a lot of records. There's thick 1,000 pages of records, and they tend to drug you up, and they tend to send you a lot of group therapy. So the records aren't always all that helpful. So I think that's part of it. I think that there is, not at the judge level, but I think at the administrative level, there's a sense of, well, you're getting VA benefits. Why do you need Social Security benefits as well? You get in front of a judge and, you have symptoms that are really significant. I think you got a shot at it. Also, my experience has been a lot of combat veterans, they're tough people. I mean, you've been through hell. You've been to combat, you've been shot at, you've had people killed near you, explosions, burn pits, all that kind of stuff. And so a lot of times those folks aren't real forthcoming when it comes to talking about what's going on inside. And they don't really explain it particularly well to the therapist. And they're going to the VA and they're kind of being rushed in or out, or it's teletherapy. A lot of times it's better if you can to go to an outside psychiatrist or psychologist and, just get another opinion. But that's why it's just that it's all about the record, and again, I've said this many times that in my opinion, what it takes to win a mental health case is some indicia of severity, inpatient hospitalizations, suicide attempts, multiple failed medication trials, inpatient hospitalizations. A lot of people at the VA have not get treatment at the VA, haven't had that. So, a judge sees it, it's like, well, this is a combat veteran. A lot of combat veterans suffer from PTSD. What makes this one different? So you got to do something to differentiate yourself. And that's hard to do. But anyway, that's probably the reason why. So, I wish the best. And again, I know from talking to previous clients, that's a really, really difficult thing to go through. And again, I appreciate your sacrifice. We all do. I mean, folks like you who put your life on the line, and I think most people have no idea what that's about. Just from talking to people that have gone through that, I just have an idea. And again, in fact, sometimes I talk to folks and I say, when people talk about PTSD, all these people applying for PTSD, like, can you imagine being in a combat zone for 8, 9, 12 months and every day knowing that somebody's trying to kill you and having your best friend blown up, or being in let's say on a vehicle, and all of a sudden you're talking to somebody, the next thing you know his head got blown off, or you happen to miss a day because of something, you had to go to the dentist, and that day the people you were with got blown up. Survivor's guilt, and just this crazy, how do you survive that level of stress, body being under stress for 8, 9, 12 months, things like that. So really, really tough, really tough. And again, I wish I could, and I know the VAs, they do the best they can, but they limit the amount of treatment you get. It's a tough thing. But I think bottom line is, if you can go outside the VA, that would be good. Sweet Candy. After I send my adult function report and my worker needs more information from more doctors, how long it will be for my worker? It just depends on how busy they are. And again, it's going to be a matter of months. It's not going to be a week or two. It's going to be months. So I would say, you send it in, and the whole process at initial, 8, 12 months, recon 7, 11, 12 months, so I think you're looking at months. I can't give you a specific number, but certainly months. Okay. Teresa says, if you already have an attorney, can you switch to another attorney while still waiting review? You can. I discourage it because, there's a lot of time in a Social Security case where nothing really happens, and it's really not fair to blame your attorney. I mean, there's nothing much that the attorney can do while we're waiting for the adjudicator to gather medical records. And so it's not your attorney's fault. That's number one. Number two is, if your attorney's had the case for a while and has, set up a file and has done work on it, in order to get another attorney, your first attorney has to waive fees, withdraw and waive fees. And if somebody's had a case for a year, year and a half, or even 6 months, they're going to say, I did some work on it. And they may not want to waive fees. And if they won't waive fees, then both attorneys have to file a fee petition. And the fee petitions are a freaking disaster, I got to tell you. I've got several of them outstanding. It'll be years before, if you ever get paid. I've got some I'll never get paid on. And so I won't take a case if I have to file a fee petition. So if somebody calls me with the best case, a great case, 58 years old with 3 herniated discs and, all kind of other medical problems, but they have an attorney who doesn't do anything, let's say. I'm going to say, if your attorney won't waive fees, then I'll never get paid on this case. I'll win it, but I'm not going to get paid on it. I just can't take it. So basically, in that situation, I would just say, if the other attorney either will agree to accept a certain amount of money, $500 or $1,000, from the new attorney, or will waive fees entirely, then I would look at it. But try to work things out with your existing attorney. And I think there's another element here is, I personally don't want to be known as an attorney who poaches or steals cases. I don't like it when people do it to me. There are a few attorneys out there who are known to do that. Not a lot, but there are some. And, my attitude is, if somebody emails me and says, I hate my attorney, I'm like, talk to him, talk to her. If I know the person, I may even drop a note. You got an unhappy client, give them a call. It's best to stick with what you got, unless there's a real good reason for it. And again, in my scenario, I would only consider taking on another case if the prior attorney waived fees or agreed to accept a relatively small amount. But don't blame the attorney because of the long delays. It's not his or her fault. Falcon Den. I'm still trying to understand how my parents made it on Pop's retirement. Living on a fixed budget is not a walk in the park. You are absolutely right. I mean, things, everybody knows, eggs are the latest thing. I saw on the news today, $8, $10, $12 for a dozen eggs. That's pretty crazy. Eggs were used to be a cheap source of protein, $2.50, $3 for a dozen, and now it's $1 an egg. And so, yeah, it's a real problem, and trying to, live on a small retirement it's very, very tough. It is really tough out there. And, I think that, look, Social Security was never intended to be a, a full-scale retirement program. It was designed to supplement pensions and things like that. But now there are no pensions anymore. It's just, it's not a lot of money. It's just not a lot of money. And, I talked to a lot of people. I've had a number of clients, some of whom have been on this live stream, who were making really good money, six figures. And because of medical problems, they can't work anymore. And now they're getting, $25,000, $30,000 a year when they were making $120,000. Well, they can't pay their bills. They're going to have to give up their house, their car. It's really, really tough. It's really, really tough. And I don't have an answer for you. Sandra Hayward, I have a hearing next week. Our rep is not a lawyer called today and for no reason dropped me. What are my options? Should I attend the hearing and ask for more time? Yeah, I think I would, well, first of all, if there's no reason, I think you need to ask that rep, you have a non-attorney rep, to withdraw and waive fees. And the form to do that is called the 1696 SUP, SUP2. The 1696, I'll put that in the comments here, 1696 SUP2. So they need to withdraw and waive fees if they dropped you at the last minute. They're really not supposed to do that. If you have a hearing scheduled, Social Security's regulations say that you're not really supposed to be able to get out of it at that point. You're leaving somebody in the lurch. So a couple of options. One is, appear at the hearing and say to the judge, look, my attorney dropped me a week ago and I'm not real happy about it. And the judge might not be happy about it either. But then again, if you really want a representative who doesn't want your case, but I would certainly ask the rep, the non-attorney rep, to withdraw and waive fees. You can ask the judge for a reset hearing. They'll probably give it to you. Then you have to reach out to other lawyers. And I would tell you, probably look for a lawyer as opposed to a non-attorney rep. Although there's some good non-attorney reps, I'm not going to demean them. But I think I would look for somebody, whether it's a non-attorney rep or an attorney. But it's going to make it a lot easier to do it if you have a 1696 SUP2 in hand, because that way, you're not going to be dealing with fee petitions. But that's too bad that happened. And I would also, as said, ask for a copy of the file, the exhibit file. So if you take it to somebody else, you can give them a copy of the exhibit file, and they should be able to send it to you as a PDF. Laura Zamarippa, that's an interesting, Laura, I'm sure that you've had teachers and people just brutally destroy your name, mangle it for years, because Zamarippa is a difficult name to pronounce. Irrelevant to anything, but I know because Ginsberg, I had the same problem. I can't tell how many times people misspell it, Gainsberg, Gainsborough, Goldberg, you name it. I sympathize with you. My mom had a last name that started with a Z, and so same issue there. But anyway, can my attorney letter saying I'm disabled not work be sufficient for a handicap placard in Texas? I think you have to sign by a doctor, Laura. I don't think your attorney can do it. I think it's got to be signed by a doctor. Esoteric with the TBI. Are they going to accept people? Are they going to start accepting? I think you mean accepting, meaning approving people for disability for long COVID. Yeah, long COVID is recognized as a potentially disabling condition, especially if you have complications with breathing and your heart. That seems to be what moves the meter with long COVID. But yeah, they recognize, there have been a number of emergency messages out there where they recognize that long COVID is a thing. But, again, there's no consensus in the medical community as to exactly what it is. It's like fibromyalgia. It's like, chronic fatigue. It's there, but it's a matter of degree. You have, long COVID, you may have 5 people diagnosed with long COVID, and, 1 or 2 of those people may be disabled. Other people may be mildly impaired. Loss of taste. The sense of taste is technically a symptom of long COVID. Is that going to prevent you from working? No. But, if you have fatigue, if you have chronic pain, if you have, balance issues, if you have breathing problems, if you have your heart's not, if heart infections, that could be. Look, one of my closest friends had COVID a couple of times, and in the summertime we play tennis together. It gets really hot. He runs around. His heart rate is a lot higher than mine, and he has to stop sometimes. Mine will be 110, he'll be 180. And we're doing the same thing. So, it can be, in his case, it impacts his tennis game. Other people, it can impact their daily life. So it just depends on the degree of it. But yes, long COVID is a thing. Ku Thunder says, good evening, and everyone hit the like button. Yes. Madeline is a legal assistant in my office, does a great job. Madeline does a lot of the call screening for me, and we're emailing and communicating by text a lot about different cases, and is a very, very nice person. Just got a new, what did you get, Madeline? It wasn't a dog, it was something, it was a new pet of some type. Was it a gerbil or something? But I think just got a new pet. So I'm sure that you are getting used to that. Esoteric Fitness, can you get disability if you have enough credits? No. You can get SSI, but you cannot get SSDI. You have to have credits. That is a mathematical issue. It's not a matter of disability. Myra York says, lumbar fusion, pinched nerve in the leg. I'm 60, worked 40 years, same job. That helps. Surgeon says, can't ever do an old job. It's a manufacturing plant, earn an STD. So short-term disability for 6 months. Does it affect the back date for disability? No. It does not. Getting short-term or long-term disability is not impacted. Now, the long-term or short-term carrier may ask you to repay them for months where you were getting both, because that's what the policy says, but it does not affect the Social Security side of it. So getting that money, VA money, long-term, short-term, anything like that does not affect Social Security at all. Guilty. One, hope you're not guilty of anything significant. Maybe you're guilty, I don't know. After 4 years, I finally awarded a fully favorable decision. New York City, 2021 onset, they approved 2025. It depends on when you applied. You can get paid up to 1 year prior to application. If you applied in 2021 or 22, then your past due benefits go back to 21. If you applied in 24, then you can go back to 23. So you only go back 1 year from the date of application. Now the onset date, the 5-month waiting period can run before you're eligible for payments. So let's say you applied at let's just say November of 24. So you get paid earliest November of 23. The 5-month waiting period can run from 2021. And then in 23, you start getting paid, that full year. So then it's a little confusing, but it really depends on when you applied. But I think that if you finally got it after 4 years and you applied 3 or 4 years ago, you could be looking at a substantial sum of money. King's daughter, would getting a disability placard, even if temporary, and a rollator and a shower transfer chair help your case? Be 50. Yeah, I think it will help your case, because again, these are activities of daily living that are impacted by your medical issue. And, the placard means a doctor has said that you have difficulty, with walking, with ambulation, that you need to be in a handicap, parking space. A rollator and a shower transfer chair mean that you cannot walk unassisted. That is important. And certainly at 50, you got the sedentary and grid rules could apply, because I think if you've got a rollator, by definition, you can't be doing light work, since it means standing and walking 6 hours a day, lifting 10 pounds frequently, 20 pounds on occasion. Can't do it if you got both hands on a rollator. But at 49, it's going to be, so here's the risk that they approve you as of your 50th birthday, but not before then. Not that you shouldn't try, but that could be what happens. And I'm seeing more and more of that where they change the onset date. Bracy Fam 80. I have SSDI mental health and back injury appointment this week. Any suggestions? Yeah, I would say take notes. I would write down what happened. I think that you want to be in the mental health exam, do the best you can, answer all the questions. Some of them may seem silly, spell this word backwards, count backwards by series of sevens, name the last 5 presidents, things like that. Do the best you can. Don't try to fail any part of the test. Be honest with the evaluator. My experience has been the mental health evaluations are usually fairly reasonable. So I would do the best you can with the physical. Probably a waste of time, but I would again try to be very specific about the things you cannot do. Realize that they'll be watching you when you walk in from the parking lot. So, assuming that you have issues with walking or your back, don't exaggerate when you get in. Walk the way you walk, act the way you normally act. From the time you just always, you want to be completely truthful. Nobody, none of us, any of us, I'm including myself in this. First of all, you should never be trying to outsmart a doctor for purposes of getting a disability. It's going to backfire. And the second thing is doctors are trained, especially doctors who deal in the disability world. And a lot of these consultative doctors do work for insurance companies. They are trained to look for, secondary gain, malingering. They're trained to look for people who are exaggerating or faking. For many reasons, don't even try. Just tell the truth. Tell the truth, but be specific. Try to stay away from not very long or not very far, 10 minutes, 15 minutes, 30 feet, 50 pounds, 20 pounds, whatever it may be. And think about it ahead of time, like lifting. A gallon of milk's 8 pounds. Can you lift a gallon of milk comfortably? A lot of people think, I could do 20 pounds. 20 pounds is a lot of weight. I'm pretty strong. Picking up 20 pounds like in a box of paper, let's say, it's I can do it, but it's not easy. And I suspect someone with back problems is going to have a real hard time doing it. And, my back is bothering me. 20 pounds is a lot. So, think about it. Try to pick up a gallon of milk. See if you have problems with that. But I think, people, you shouldn't think about this for the first time when you're being asked about it. So, again, just think about, how long you could really walk, uneven terrain versus flat. Is it, 10 minutes, 15 minutes, and maybe try it and see what happens. Lifting, bending, do you have trouble getting off the floor if you bend down? Do you have to if you had gotten in the bathtub, you need help getting out? Things like that you probably don't think about, but they're very, very important. And you need to have answers to those things. Barbara Prince says, thank you, Barbara. You're very welcome, and thank you for tuning in. Giselle, I think we had Giselle, we had 2 Giselles last week, I believe. So this is Giselle, I'm thinking from last week, I don't know. Maybe this is the 3rd Giselle. So we're having a run of Giselles, who knows? I'm a 54-year-old female and I've been diagnosed with sciatica, currently disabled. Do you think my case can be approved for SSDI? It depends on how bad the sciatica is. It's something that where you can't stand. Realize if you are limited to sedentary work, and that's no more than 2 hours standing, if you can't, if you can't even stand for 2 hours, that's going to put you at a reduced range of sedentary, and you've got pain, or you're on pain medications like Neurontin, which they would give for a nerve pain, then you might meet the grid at the sedentary grids. Go to gridrules.net to look at them. Let me put that up here, by the way. But you might very well meet the grids at sedentary at 54 with bad sciatica, but it's got to be, significant, because just having a diagnosis of sciatica or that nerve pain running down your leg does not make you disabled. It's just a matter of how bad it is really the question. But it could be. So the answer is possibly. It just depends on the severity of it. Salim says, I have facial diplegia with injury, brain injury, also a hernia, take lots of medications, not 55. I think that I'm not sure what facial diplegia is, maybe some sort of a spasm or issue with movement of the muscles in your face. Brain injury, significant herniated disc, you're 55, to me that would be worthy of a long look, because I think you very well might meet the grid rule as of age 55, because, herniated disc and brain injury is going to make it hard to focus and concentrate. Probably can't, lift 20 pounds, stand for 6 hours. I think you probably have a good case, assuming the medical supports it. Vince, my client Vince, good evening. How are you doing, Vince? Vince, you're in Chicago or Detroit? I can't remember, but one of the two. Like it is. How are you doing? Like it is. Terry says, all 3 of my functional reports say I need unscheduled breaks daily, miss 3 or 4 days of work. If the judge accepts that, you win. Absolutely, you win. That would be a strong case. Case evaluation. I know I got to put that back up here. I got to come up with some better crawls here, but I want people to call me if they need help. Can you look up my approval rate for the names here in Albany or all ALJs? Let me give you the link to what I use, and I will tell you. You can look it up yourself. I don't want to call it a judge on here, just because it's just I don't want to be in a situation where I don't think that's appropriate for me to do that. But I'm going to give you a link as to what I use. It's a little bit outdated, but I think it still gives you a pretty good idea. And just look up the judge. Just do a search on the judge's name, and that will tell you what the percentage is. And that doesn't really mean you're going to lose. Now, again, if you get 17%, that's not a good sign. I've got him coming up in a couple of weeks, by the way, here in Atlanta. But even judges that are 33%, 40%, they still approve cases, and I win cases. I have 2 favorable decisions this week from judges that are approved in the 40s. So it happens all the time. St. Louis says breaking up videos. I asked about that. Have you guys looked at my videos? I'm not sure if I've got them out yet. I've got somebody who's putting them all together for me, but it's very common to put the live stream into segments. So good. So I hope you find it helpful. Okay, thank you, Kings. I appreciate that very much. I do want to help folks, and I have a good time with this. And I like talking about it, and I like explaining it because, look, it's not a lot of good information out there. And if I can answer your questions, I'm happy to do so. But thank you for your kind words. I really appreciate that. And if you have a chance, leave me a nice review. And again, I'll put that up here. Like those reviews, they really do help. Joey is 61 years old, been an SSD for 5 years. Thinking about working 400 to 500 hours a month, jeopardized. Nah, not at 61. I think you're going to be fine. I don't think it'll be a problem at all. I just think that, if you're 31, yeah, it'd be a problem. 61, no, I don't think it'd be a problem. Jim says, looking to file for disability. I have local attorneys who have been denied. Why is that? I don't know. The only thing I can think is, I've had a few situations where the case looks like it's clearly going to be approved. In that case, I'll tell somebody, don't hire an attorney because you don't need to pay anybody anything. Some attorneys just don't want to mess with it. I personally, I file applications for people all the time. Now, if you've already filed your application, you're waiting for a decision, I might say, why don't you wait, just because there's no reason to pay me, when you've done all the work. That's just the right thing to do. But as far as getting someone to file an application, if it's a good case, I'll file an application. Have somebody in my office, that's all she does. Files applications and prepares the recon and the hearing appeals. Do it all the time. So I don't know what that's all about. That's kind of an old-fashioned way of looking at it. It used to be people would say, call me if you got denied, but I like to get involved as early as I can. If I get somebody approved early, they're thrilled. I get a great review. Maybe I'll make $500-600. It's a win-win for everybody. So why not? Why not? St. Louis Grand. Martindale, yes, there is a site, I think lawyers.com. Martindale Hubbell is a company that is known for rating attorneys. And basically, they give you a rating. It's called an AV rating. It has to do with ethics and ability. And I'm fortunate I'm ranked AV, which means it's the highest you can get rated. But again, other attorneys are not been nice enough to grade me that. I'm also on the super lawyers list, which is also very. I don't like to sort of brag on myself, but that's a nice thing that I was nominated by other people for that. But yeah, Martindale, I think is they're all together now. They're all been bought out, but it's basically another site where people can. I kind of look for reviews at Google, Google, Avo. There are a few other places, Facebook. That's where most people are going these days. Yelp to some degree. Martindale Hubbell. I'll take them from anywhere, but I sort of believe I like to get my reviews concentrated because most people are going to look at Google. I got like 250 Google reviews. Most of them are pretty good. Actually very good. I actually have one on there where somebody gave me 1 star and said I did a great job. I think she misunderstood 1 star versus 5 star. And I've had a couple people that, were unhappy because I didn't take their case. And so they gave me a 1-star. But, anybody I've represented, for the most part, I've gotten pretty good reviews for. We work hard. It's not, I will tell you, it's not just me. You see Jen's on here, Madeline's on here. This is their time. This is their free time. They don't have to be on here, but they care. All my staff, Iris, who's a medical doctor in Guatemala, she doesn't get on the live stream very much, but, they really care. In fact, when we win, those of you who are my clients that have won, this, I send out an email, that with a copy of the decision. Congratulations, you won. I send a copy to everybody in my staff, the copy of that email, and everybody chimes in like, congratulations, it was a pleasure to work with you. We really appreciate the opportunity. And it's kind of a group thing. We're not a big firm, and we all, take it very personally when we win. We love it. And if we don't win, we also are not real happy about it. But yeah, it's a group effort. It's not just me. So I'm very fortunate. I've got a very good team working with me, because there's no way one person could do it all. And, we got a lot of, have not a big staff, but, I've got enough people out there, 6, 7 people, and they work really hard. So I'm very fortunate. Glutenless Sin City. So I'm thinking you're gluten-free and you live in Nashville, maybe. I have one hearing back in December, 100% VA, waiting my second hearing in May. It's unusual to do a second hearing, but not that uncommon, but it's, I'd say 5% of cases. So hopefully you get a good result with that second hearing. Nathan, I can understand pulling myself up by my own bootstraps, but if I'm disabled, the president dumpster won't let me get a job. What do you expect I do? I think that there is a myth out there that we should all pull ourselves up by our own bootstraps. Easier said than done. And look, the grid rules exist because they recognize that people with a significant medical problem are going to have a hard time finding a job. So yeah, it is a problem finding a job when you have a significant medical problem that may require accommodations. And so, yeah, there can be a disconnect between, you're disabled enough where in real life, getting a job is impossible, but Social Security deciding that, well, you could work some job that doesn't really exist, but theoretically you could. And there can be a disconnect there, no question. When you're on disability living in taxpayer handouts, people treat you like you are stupid and dirt. Well, it's not taxpayer handout. Realize you paid into the system. So it's not a handout. It's this is the same as Social Security retirement, same trust fund. But yeah, some people, until it happens to them, I'll just say it that way, until it happens to them. And I've had a number of people, clients have come to me and said, before I was disabled, I thought this whole system was a bunch of fraud and scam. Now I got 3 herniated discs. I get it. And yeah, and I have this conversation, I will tell you, with friends, people that I know that, have done pretty well in life and work hard. I'm not demeaning what they do, but it's full of fraud. Like, how do you know that? You're just sort of saying that. I get this one friend of mine, I think I've mentioned him before, I've known for years and years, and his wife is very, very left. She's very much a very solid Democrat. I suspect he is as well. And he's like, it's all kind of fraud and Social Security. I'm like, what are you talking about? I do this on a day-to-day basis for 35 years. There's not a lot of fraud. I'm not saying there's none, but most people, this is not a free lunch at all. So, there's that perception out there. Tara Denise, who's a very young person. It's your daughter, not her. Okay. 22 with mental health, she's 52. Now, if you're on SSDI, yes, because your daughter might be a disabled adult child, and that would be a better program to go with. So yes, you could pursue benefits for her as a disabled, it's called the DAC, disabled adult child. I don't have time to go into detail, but basically she became disabled, I think, before age 18, or was it 23? I don't remember. Let me look it up because I need to know. I don't want to tell you wrong. DAC requirements. Before 22. Okay, so she became disabled, which she clearly has based on what you said, before 22, and she's disabled. And you're going to SSDI, she could be a disabled adult child, and that would be a better program than SSI. So that's what I would do. Absolutely. Let's see. Okay, we're getting a little short on time. We've got 5 or 6 more minutes here. I'll fight for mine again. I can't lift fry baskets. My hand goes numb. Again, lifting, is a requirement of most jobs, using the hands. All right. And Jim is one who's having trouble finding a lawyer. And Deb, who's a regular here, says maybe you don't have enough credits for SSDI. Could be. All right, I was given SSDI. I was 56. Beginning. What would be the hearing? I don't understand, Sandy. Why would you be having a hearing if you've been awarded SSDI? Unless you're doing a review hearing. I don't know what kind of hearing. Okay, try to fire my attorney for doing nothing at all. I got my lawyer. So yeah, this is the problem. I mean, if your attorney's been on the case, for a period of time, a year and a half, and you fire him, he's going to say, okay, I want to get paid anyway, and I want to file a fee petition. Then your second attorney is going to say, there's not enough money here because I have to file a fee petition too, and it's never going to get processed. I'm not going to take it. So you got to move really slowly. And again, before I would even think about firing an attorney, I'd have a long talk with him or her and, try to work it out. And if you can't, just say, look, then if we're in an impasse, will you waive fees? And if you won't waive fees, how much do you want? And then before you let him go, talk to somebody else and say, look, my other attorney said he would accept $1,000 and the fee now is $9,200. So, if somebody came to me and says, my prior attorney will take $1,000, will you take the case as a good case? Yeah, I would take that. But, you got to have the other attorney in agreement. And the time after you fired him, there's no more leverage at that point. So I would move slowly on that. Okay, interesting question. Fingerprinting gurus. He was approved for SSDI, waiting your back pay. You mistakenly applied for SSI, which you're probably not eligible for non-medically. And now you got to complete all the SSI paperwork. That slows things down. Seen it happen a number of times. When you're applying for benefits, if you're not eligible for SSI, and find out if you are, based on household income, assets, don't apply for it because it's going to slow things down. Or dismiss your SSI case before the case is approved. But the best is not to apply for it at all if you don't qualify for it. Yes, Deb's asking the same question I am. Why would you have a hearing? Maybe she means a CDR. How long can you appeal a denial? You have 60 days to appeal it. 60 days. Okay, so T-Cash says I'm 60, approved back pay was $28,000. The attorney took $7,000, 25%. My 1099 list should not. It should only list what you actually got. So you might want to double check the explanation of benefits and make sure that the $28,000 is, because I've never seen that happen before. Not to say it couldn't, but maybe that the total back pay was $35,000, you got $28,000, and your 1099 was for $28,000. But you want to double check that. But I've never seen that happen before, where they send you a 1099 for money you didn't receive. Once approved payments are made back to date of application, it's date of onset minus the 5 months for SSDI, assuming you have applied, within a year of your onset. So in other words, I talked about, I gave you an example before. If your onset is 2021, you applied 2024, you're not going to get paid but from 23 on, because you can only get paid 1 year prior. But the onset is when you became disabled. So you can always get paid as of onset, but if you applied within a year of the onset date, you'll get paid back to onset less the 5-month waiting period. I can tell you stories about being on the client. You would give you nightmares like it does me. Yeah, email me. I'd like to hear those stories because it's, it's useful to find out what happened. Yeah, I'd be curious to know about those stories. Can I receive my retirement and SSDI, says Martini Shah, with an onset date of August? Generally speaking, if you're eligible for retirement, early retirement, you get on SSDI, you'll get full retirement amounts. So you don't double dip. You can't get both. You get the higher of the two, which is typically disability. Okay. All right. We're getting down to the I've got a lot of great questions here. I'm sorry I'm not going to get to everybody because there's no way I can get to everybody with just a few minutes left. And somebody just gave me $10. Ruth Rosario. Ruth, you did that last week, and I really appreciate it. Thank you very, very much. As I mentioned, my son is my video editor, and he gets a sandwich out of it. I may get a sandwich too, but he's going to get one because he's a good guy, and he does my videos in a timely manner. If the rules get changed, ask Golfer Pro, will it affect people awaiting hearings on new cases? Typically, they put a date for new rules. Sometimes it affects pending cases, and sometimes it only affects cases as of the application date. So it may or may not, depends on what the change is. I know that's kind of vague, but it just depends. Some of the new rules do affect old cases, some of them do not. Okay, Linda Hill applied 51 hasn't worked for 10 years, then it says to me there may be a problem with getting enough credits. That could be the issue there. So you might want to get your My Social Security statement and see if you have enough credits for SSDI. Christina, thank you for liking and sharing. Yes, thank you very much. 219 viewers, great. That's awesome. I love it. I love it. Christina, smash. Don't just press it. Smash that SOB. Smash that like button. Absolutely. Thanks. You are welcome. You are very welcome. Okay. Great. Thanks, K. Wolf. I appreciate it. All right. Let me ask. Good evening, Jeff. How are you doing? Roberts, one of my clients. I received my work history report form, filled them out to say fax would be good to send them as well. Went to an ink test. You can fax it. I mean, you can send it to us. We'll submit them electronically. It doesn't matter, whatever is easier for you. I like to get a copy of it though, so send me a copy. But yeah, you can fax it, but you want to have that barcode. We always tell our clients, if you got forms to fill, just send them to us, send them to Jen. We'll get them sent in. That's probably a better way to do it. Okay, I got time for just a couple more questions. Let's see. Barbara says she was not clear. I was approved for SSI. Judge wanted to give me more to the evidence, but he said I need 60 more hours of work credits, 57. So it sounds like you were awarded SSI. The judge says I would have awarded, SSDI, but you're not. I think you need 20 credits in the last 40 quarters. I don't know about 60 more hours. Maybe you need a certain number of more credits, but it sounds like you just didn't have enough credits as of your onset date is my guess. Filled out your 455. Have discussed work with my doctor. No, I don't think the doctor, you don't need to discuss work with your doctor. That's really not, doctors, you discuss medical issues with your doctor. What is the percentage of getting approved for SSDI appeal hearing, like the ALJ hearing? Right now, it's just under 50%, and I'll go over these numbers. Initial application, about 35% are approved. Those are usually people with something really significant. People who appeal, recon, about 12 to 15%. People go to hearing, about 48%. So it's pretty high, relatively speaking, at hearing. Then at the appeals council, like 10%. Federal court, it's a little higher than that, but they don't take every case. So it's not really the same thing. Ginsberg, I got called Gainsberger when I was in school. Yes, absolutely. Thank you for bringing it up. Pitbull Winkle, appreciate that. Bad memory. Now I'm going to think about that all night. Okay, Kenneth Thompson, been watching, very supportive. I left mental, was not able to hold a job. Yeah, that would be helpful. That would be helpful, that kind of letter. And chronic migraines, yes. Those things always help. Having a doctor give you some discussion about your past work. Okay, let me get okay, so Madeline tells, she got her girls a dwarf hamster. It's been fun. Hamsters, I had buddy of mine when I was growing up was allergic to everything. My friend Steve, he was allergic to everything growing up, so he couldn't have a dog. I had a little dog. Steve lived down the street, and he had gerbils and hamsters, and he wouldn't, he could handle them because he wasn't allergic to them. And they were fine. I mean, I didn't think a dog is more fun than a hamster personally, but they're little, and I think for little girls they're probably not as scary. So yeah, hopefully the hamster's got a is a got a nice personality. I don't know what kind of personalities hamsters have, but Madeline, I hope your hamsters are giving you a lot of joy. Okay, let's see if I have. Okay. Vince tells me he's in Michigan, not Chicago. Okay, I'll remember that next time. Okay, so we'll make this the last one. Craig Campbell says, I had my hearing yesterday. At the end, the VE was asked if I do any job, if I required an extra 15-minute break. VE says no jobs. If the judge accepts that part of the hypothetical as your functional capacity, then you won. I've had people tell me the VE said no jobs, but I got denied. Then I listened to the hearing record, and the judge asked 5 questions of the VE, and one of them said no jobs, but 3 of them identified jobs. So if that's the only question, or that's the main question, then yeah, you probably won. But realize judges many times will ask a question at the end, assume 15% of the day off task, assume 3 days of work missed. What does that mean? They ask every case, they ask the VE that. VE says no jobs. Doesn't mean you won. It just means that they're going through the exercise of proving it. Hopefully you did win, but that's what that could mean. So, okay. All right. So we are now at 2 hours and 35 minutes. I will need to go. I appreciate that we had a great turnout tonight, and I really appreciate that. Next week, remember, if all goes well, I'm going to have Adriana Del Toro on here, who is an appeals specialist, and Adriana is going to talk about some of the issues that arise at the Appeals Council and federal court, as well as at hearings. And we'll hear from her about some of the new stuff coming down and some of the interesting cases that she's handling. And I think we'll all learn something from it. I hope I pronounced her name right. But anyway, Adriana is going to be here hopefully next week, and I'll put something out there pretty soon, maybe the next day or so. So I hope to see everybody here next week. In the meantime, stay warm, take care of yourselves, and we will see you next week. Thanks a lot.